Ladies and gentlemen, welcome to today's webinar. Today's presentation is part of our first 30-minute series. Today's topic is COVID-19 legal update for the medical community and those who advise them, keeping up with a rapidly changing landscape. Our presenter today is attorney Eric Boughman. If you'd like a copy of today's presentation, you'll find it in the handout section of the webinar interface. Similarly, if you have a question, you can type it into the questions section of the webinar interface. And now let me turn it over to our presenter. Go ahead, Eric.
All right, thank you very much, Tony, for the introduction, and thank you everyone for joining us today. We have been doing these 30-minute presentations on a regular basis, and happy to do them. These are an overview of some of the either current events, legal issues that are popping up in the news, or some common questions that we get in our practice from other advisors and the folks that we deal with. And what I'm going to talk about is stuff we might talk about in the first 30 minutes or so of a conversation with somebody during one of these conferences. So obviously the big news of late is everything surrounding coronavirus. A couple weeks ago, we talked about some of the changes that were going on in the world of healthcare with respect to licensing and payment to allow providers to get paid, especially via telehealth or telemedicine, and some of the waivers that were allowing that to be possible. I told you as updates came out that we would try to get you more updates on that. We squeezed in another session a couple weeks ago because we were getting a lot of calls and talking to clients. People are nervous, not only about the health aspect and from a, what can we do as far as generating income in our health practice. We are also talking to people who are nervous about the economic downturn and what the long-term repercussions were. So we talked about that a little bit in the last session. And as I promised, I would bring you some updates today. As it would happen over the past few weeks, I've been trying to keep up with changing laws and developments and rules as they come out. And a lot of what we've been following in Florida now just got flipped on its head with the governor's new order yesterday. So I've taken a look at that. You've probably heard a little bit on the news, but I'll cover that and what I think is applicable to the audience today. In the meantime, if you do have questions, I will try to take them during the webinar. And if I don't get to them, or if you think of something afterwards that we didn't talk about, feel free to reach out. You can contact me by email or by telephone. And especially in this environment, I'd love to have your calls, questions, and the communication. We can do that via phone, or we can do it via some type of video conferencing mechanism. So here's an agenda of what we will talk about over the next 30 minutes. And I'm going to squeeze in some, really as we look forward on how we're going to, what's going on right now, but how are we going to restart? What's this going to look like from a policy perspective? What are we anticipating some of the issues that people are going to have, the questions over the next, not just the next few weeks, but the next few months, and really probably throughout the rest of the year. I know a lot of people are worried, and we're going to try and address some of that in this webinar and in our next session as well. Of course, this all started, coronavirus coming into the U.S., national order that declared a national emergency. It was declared in March, but essentially made effective going back to January. And what that did is, the importance of that is it allows, it essentially triggers other waivers and rules and the ability for other agencies, both at a federal level and a state level, to take certain actions. So we saw that again a couple weeks ago with telehealth. We saw a response from CMS where they exercised authority under Section 1135 of the Social Security Act to waive certain requirements that were previously in place with respect to telehealth. And so that's the effect, and I want to just talk about that for a moment, why that's important that we have that national emergency declaration order, because it allows some of these other things that we talk about to go into effect. Similarly, in Florida, we had an executive order also declaring a national emergency. Very similar. That then triggers other actions and orders by other agencies, and we've seen a few orders from the Department of Health that essentially rely on the emergency declaration that came out of the governor's office. And one, the important one in the healthcare arena is this order, 20-002, that opened up essentially avenues for participation by out-of-state practitioners to practice telehealth with a relaxing of the requirements that would normally apply for out-of-state practitioners. So you still had to meet some of the basic requirements, but you didn't have to go through the full registration that's required under the telehealth statute, and that was to help deal with some of the emergency issues that we're dealing with in the state. We've also seen licensing deadlines be extended. So if your license is up for renewal, DOH in this 20-003 extended the licensing deadlines, so you have more time to get your licensing renewed if that's something that you're subject to right now. And all of these orders, whenever there's an order that's been issued, it typically, if it doesn't have an end date stated in the order, they often don't. They typically will run concurrent with the executive orders declaring the emergency. And then sometimes when the governor makes an order, he will issue an executive order, and it may have a stop date, and maybe he'll issue a subsequent order that extends that date, or sometimes it will just go into effect and it will run concurrent to another order. So when you see that, you'll often see this runs concurrent to Executive Order 20-52, and then we see that that order may be extended or modified by subsequent orders. So if you're relying, the reason I point that out, if you're relying on an order that is making a temporary change to, on either licensing or payment or some other issue, you need to make sure you understand when that order is in effect and when the effect of the order stops. If you have any questions about that in detail, you want to know something specifically about the order, again, feel free to reach out and let's talk about that. A couple other things that happened, some of them that may not affect us directly, but it does, it just shows a general policy of how the government and how healthcare in particular have responded to the national emergency. You see the Defense Production Act being executed here, and then of course in April when CMS came out with their policy revisions to allow more flexibility for treatment and for provider flexibility with respect to dealing with the public health emergency. For instance, facilities were opened up that could provide emergency services, ambulatory surgical centers, and other temporary facilities that were allowed to now provide services that may have been restricted typically under the regular regime. We also saw capacity changes with respect to what the requirements were under agency requirements. All of this is, again, stems from the governor's executive order and the DOH order. I mentioned earlier the CMS Section 1135 waiver, and that is the mechanism that CMS used to open up essentially a lot more services for telehealth coverage, both to pay for telehealth and provide additional funding. So we've seen acts, the CARES Act, of course, and then there's been subsequent bills that have been passed with funding to deal with the coronavirus. Substantial amounts of money have been dedicated towards dealing with the coronavirus directly, and also towards dealing with testing and tracking and so forth with respect to the coronavirus, and also for coverage generally, both for Medicare and for the healthcare facilities to receive additional funding. The telehealth, if you didn't get to join us on the last one, basic overview of telehealth. Why we're seeing that a lot more is because CMS essentially announced two significant changes to what they would pay for. The first is that beneficiaries could be covered wherever they were located. So traditionally, Medicare would only pay for telehealth services if the beneficiary or the recipient of those services was in a rural area, and that recipient had to travel to a specific location and then meet via video conference with a practitioner who was at another location. So you had the originating site, and you had the remote site, and you had these strict requirements. You also had strict requirements with respect to the modalities of communication. with the 1135 waiver, CMS essentially said, we're going to cover pretty much anything that would be covered under regular services. We're now going to cover those services via telehealth. So me, for instance, I had shoulder surgery a few months ago. I've had follow-up appointments with my surgeon. I've had physical therapy appointments. I've done my follow-up, and I've done most of my physical therapy via telehealth. Just simply, it's not on Medicare, but it makes it much easier, and we don't have to worry about going into a facility while we're under the stay-at-home order or the stay-at-home recommendations from both the federal and state government. So other than changing the locations where telehealth services could be provided to and from, the coverage also extends to not only video conference, but now providers can communicate with the patients via smartphone, either by video or even sometimes in some cases by phone conference. I will say, however, I caught a little article where there is starting to be some attention paid to certain phone calls that are being billed under Medicare and probably under private insurance, where authorities are starting to question whether those calls are calls that would normally be non-charged follow-up calls, just simple phone calls that wouldn't typically be charged. And now providers are charging for those calls now that they have an opportunity to do so. So if you are billing for calls, make sure you are billing those properly, and again, that they're properly billable. And be aware that we would expect probably when this is all said and done, that we'll probably see some auditing of some of that activity to discover whether or not these meetings and these appointments were properly billed. Pre-existing relationship requirements and cost sharing, I covered that in the last seminar as well, but just wanted to mention it again, with the standards being relaxed so that providers could see patients via telehealth. Cost sharing is typically a no-no. The provider could not pay for the copay or waive the copay requirement. But that's actually been relaxed to allow people to get treatment, especially because we want people going in and getting tested if they think there's concerns because of COVID, or if they have other medical issues. CMS has now waived essentially they've come out with a policy statement that essentially says we're not going to be focused on auditing people for cost sharing, for paying for co-payments and cost sharing mechanisms, or waiving those requirements. There's also been a similar push for expansion under Medicaid. In Florida, ACA administers the Medicaid program, and ACA has encouraged as much telephone contact and less face-to-face contact within the state, and that would essentially support additional telemedicine services being provided to Medicaid beneficiaries as well as the Medicare beneficiaries. We've seen some of the rules for Medicaid also being relaxed, and we've also seen the same with private insurers, where private insurers are paying for a lot of things. United Healthcare has been mentioned specifically. Other healthcare companies, I'm with United for my personal healthcare, so they've again have been very flexible in allowing me to continue to get updates and treatment while all this is going on without actually having to physically travel to the provider's office. Enforcement discretion with respect to HIPAA. Another big concern is specifically with telehealth and telemedicine is the security requirements for the modes of communication. And if you weren't using encrypted communication, you run the risk of running afoul of the HIPAA security requirements and privacy rule. And essentially OCR, the enforcement arm of HHS, has announced that they would not impose penalties for certain modes of communication as long as it's done in good faith. So now providers can use mechanisms such as FaceTime and other video call mechanisms, as long as it's not public facing. But if it's a private one-on-one video call, you're generally going to be safe. You can, I think, Google, there's Google Hangouts, there's FaceTime, another, all of these different mechanisms that people can use to provide services via telehealth without having to worry about the strict requirements of HIPAA. So again, it frees up and makes more available medical services via telemedicine and telehealth while all this is going on. And I mention that because I think we're going to see a continuation. We're going to see a policy shift as we move forward, and that policy shift, I think, is going to be towards more remote services being provided even after the national emergency is over. So that's a prediction, but it seems to be a lot of what I read and see. Once people find out how well this works, I think we're going to see a lot more of this this shift towards remote providing of healthcare services. So I'm working off of my laptop today, and it's a small screen, so forgive me if I'm bouncing around a little bit here. I'm monitoring for questions. Again, if you do have any questions, I didn't see any pop up, but I'm happy to take those. So also, there's been a lot of funding for healthcare generally and for telehealth. The FCC, Federal Communications Commission, has been granted authority to distribute $200 million to healthcare providers to use towards the purchase of the means to provide connected services. So again, I anticipate, right now it's communicating during the emergency, but I anticipate that a lot of these communication modalities are not going to die out when this is all over. So we'll see people starting to use these services, not just telephone, video call, and apps to communicate with their providers, but we're going to see that continue when the national emergency ends. I put just a couple other policy issues here, and I'm going somewhere with this National Practitioner Database fee waiver. This is similar to what this was, is the fees for using the National Practitioner Database to check a healthcare practitioner's license and look at their license history. The fees have been waived, which allows more cross-border interstate providing of services. It allows healthcare providers to move more freely between organizations and states for a temporary time to provide services. So we've seen at Florida, we've seen waivers with respect to some of the licensing requirements. We've seen the governors or the Department of Health send out notices to folks who were recently retired or resigned from practice, giving them the opportunity to come back under a waiver for a short time to serve in the COVID crisis. And we're seeing other fees and policies, licensing requirements, some of the technical requirements to move into the state and provide temporary support and services. We're seeing the organizations waive those on a temporary basis again. And I think that portends for a long-term shift in how we look at the ability of healthcare providers to move from state to state. So as we start doing more stuff remotely, as we start doing more stuff via electronic communication, I think you're going to see a lot more healthcare providers have the opportunity to provide services across state borders, and you're going to see a lot more states open up the opportunity for out-of-state providers to provide those services within the state, even after this is all over. Again, it's a prediction, but it's based on the totality of everything that I read. The trend seems to be moving that direction. And we're going to eventually, I think, see, we already see it with Nurses Compact, we're going to see more rules that allow providers to provide services in multiple states without having to go and be individually licensed in each state. I threw this note out here because it's just useful for employers. We've been asked a question here on, when we open up our office, or if we're open, can we test patients? Can we take their temperature? Are we going to run afoul of any? The question has been either with HIPAA or with ADA, the Americans with Disabilities Act, because now we're testing people as they walk in the door. And the U.S. Equal Opportunity Employment Commission has said publicly that employers may test for COVID-19 without violating or implicating the ADA. I would suspect that other agencies would follow, so that that's not going to be considered a HIPAA violation or any other type of intrusion or personal intrusion on your employees. It's going to be almost expected. I anticipate as well that in the next couple of weeks we're going to see, or over the next few months, but probably next few weeks initially as businesses start opening up, we're going to see sort of a series of best practices that businesses engage in, such as disinfecting their locations on a regular basis. There's companies now that are providing a disinfecting service and cleaning. The social distancing requirements, maybe testing for temperature, testing employees as they come in, and monitoring that situation. So you can bring your employees back, and or when you can bring your employees back, you'll be able to test them and not have to worry about running afoul. I want to watch our time here, so I got a lot of stuff I would still like to cover, and I want to talk about, this has been a program that's been in the news a lot. I'm not going to talk about the Paycheck Protection Program generally, very complicated series of events surrounding the initial funding round and the second funding round. But there are some folks in some information in here for folks in the healthcare arena, specific to healthcare. There was funding in both the first round and in the second round. And in this second round of the Paycheck Protection Program and Healthcare Enhancement Act, we saw $100 billion in the first round for healthcare related expenses and lost revenue attributable to coronavirus, and $30 billion was distributed almost immediately through Medicare registered or Medicare enrolled participants. So if you were enrolled as a provider, you were subject to being reimbursed out of that first 30 million. There was 100 million that was allocated. In the second round of funding, there was an additional 75 billion that was allocated to, again, healthcare providers, specifically for expenses and lost revenues that are directly attributed to the coronavirus. And then 25 billion with a B. These numbers are astounding for COVID testing. And interestingly, when you read the testing, it's not just testing, but it's testing and monitoring and research. And what we've seen in the news is some of these companies that are talking about being able to track people. There's privacy concerns with that, but there is funding to support this monitoring and research, which would seem to suggest that some of that money is going to be used to try and figure out how we can track individuals and perhaps even go back in time. And there's ways that you can do that with technology, is figure out where the individual is today and then go back and look through their smartphone and through communication devices that they've used on their computer over the last few weeks, see where they've been and who they may have been in contact with. So there's going to be a lot of money that's spent there, and we'll see if it's just COVID or if it gets if that has further ramifications down the line. That one will be a fun one to follow. And of course, last night we had the Florida reopening plan. I was going to talk about how the order that stopped elective surgeries in Florida and some of the restrictions as far as non-critical businesses being closed. But now we've had a new order come out last night. I did go through it. Interestingly, I've read about the order before I saw the order. I read about it and I saw a little news blurb last night. And it was not consistent with my reading of the order. So the order is not real long. If you'd like a copy of that, I can provide it to you. It's also available on the governor's website. I would encourage folks to read that. I've heard about businesses that are closed, that I don't read the order as keeping those businesses closed. But essentially, here's some of the highlights. I think the governor has taken a lot of heat. This isn't a political discussion, of course, but has taken a lot of heat for his handling of this. But whoever put together his presentation, I read the presentation this morning, early this morning, and it was very well done. And as far as relying on statistics and the hard data and what Florida has been able to accomplish. So I think congratulations are due, whether you are in favor or against performance overall. But I think with respect to how this has been handled and what the results are, the statistics are pretty favorable for how Florida has weathered this storm over the last couple of months. Who can open? Restaurants can open, retail, museums, and libraries generally. There's requirements such as you can only have 25% of your inside space. Whatever your normal inside occupancy is, you can only be at 25%. You can have outdoor seating at restaurants. You have to maintain social distancing guidance. There's some other requirements, no more than 10 people at a table. So you can look at the order. Obviously, the restaurant folks and other people that are in retail will want to look at that and find out what the requirements are. I would also note that the order says that it can be a crime to violate the requirements of the order. I think it's a second-degree misdemeanor. So you want to take that seriously. And then for the healthcare community, elective procedures may resume. So the elective procedures were closed by an earlier order, 20-72, and now we can resume. So what does that mean? Well, if pardon me, I think we have a little typo here. Again, this was we were just updating this as I was reading through the order this morning, so I apologize for that. In any event, if you are a facility that provides elective medical procedures, you have to be able to convert. If you have surgical or intensive care beds that you've converted for elective procedures, you have to be able to convert those back to deal with a surge. You have to have adequate personal protection equipment for your staff and the folks performing the procedures, and be able to respond to any COVID-19 needs without any additional federal or state assistance. And if you sought any assistance, you cannot reopen, as I read the order, if you've sought assistance again since resuming procedures. So if you're going to ask for assistance, then that's going to close you. So you need to be able to essentially stand on your own with respect to your PPE gear. And then the order also says that facilities providing elective services must support and proactively engage with skilled nursing facilities and assisted living facilities and other long-term care providers. So there's a concern there in making sure we support these other high-risk mechanisms. But the big picture news is that medical elective procedures can resume under the order. And I apologize, I don't have it in front of me. I think it goes into effect May 4th, but within the next couple of days that will go into effect. And it will essentially override the last order that, or not override, but it modifies the last order that closed a lot of the state businesses. So finally, how should we be looking at this as we go forward? There's issues with, when I'm looking at, when I'm dealing with our clients, we have a concern about getting paid. How are we going to provide services and get paid? And that's why I've spent a lot of time talking about telehealth and these alternative modalities for providing healthcare services and being paid. But on the other issue is, how are we going to deal with our obligations, our ongoing debts and obligations? We have, some folks are really busy because they're right in the middle of the crisis, and then we have other folks who are essentially closed down. We have dentists and primary care physicians and other healthcare related businesses that have not been able to see patients on a regular basis, pediatricians, eye doctors, and we're going to be looking at a lot of businesses that are facing substantial credit facility issues, both with vendors and with lenders and other credit obligations. And I've already been asked, well, can we just close the business? Are we going to be able to just close and we'll just reopen after this is all over? The answer is yes, but carefully, or yes and no. If your thought is you're going to just close your business and ditch your debt and reopen with the same location, same assets, and all the same equipment, you can't do that. You've got successor liability implications and concerns. So you have to figure out, you have to do a careful assessment. I wrote an article on this just recently. I put it on my blog. I've done a shorter version that's out for publication, and I'll circulate that. But essentially, it talks about the steps that you need to go through in an assessment of both your business circumstances and your personal circumstances to determine whether you can continue, whether you can essentially wind down without going through the bankruptcy process, which a lot of healthcare practitioners want to avoid, both business and personal, and how you can avoid that process and potentially, maybe close or negotiate with some of these credit facilities in order to survive going forward. We're going to spend our next seminar talking about some more details of that. particularly the successor liability implications. There's a fairly well-known but old case involving a healthcare, a doctor-owned healthcare facility that tried to do that several years ago back in the 90s and close and get rid of obligations and reopen the next day as a new business, and it didn't work and the obligations follow you. So how do you avoid that from happening? How do you actually work through these situations? There's several strategies for that, and that's what I'm going to get into in more detail. I'm at 12:30 and we do this for a half an hour. So a lot of material that I wanted to cover, very high level. But if anything caught your eye and you would like to specifically talk about any of these issues after the webinar today, please reach out, shoot me an email, or give me a phone call, and I'll be happy to talk to you about them. And with that, I'm going to thank you for joining us for another of this edition of the First 30 Minutes, and look forward to seeing you in a couple weeks when we talk about our next issue. Thank you and have a great day. Bye-bye.